All right, hello everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for August 12th of 2024. And Brad, I gotta tell you, I did not have a chance to look over things. I just cleared from we had a
I got
gas
him.
leak, and yeah,
I
so
got him for, one of them's clearly up your alley, but we'll talk about it. So
well, I
let's,
did write the original post, so I
I was going to
do, but
say, I
I
mean,
I usually review them again just so that I'm up to speed on all the nuances. So,
I don't think any of the viewers will pick on you.
all right.
So let's start in Cleveland. I'm a little confused by this, but I'll tell you why in a minute. So the facts are that 10 Cleveland firefighters are facing a few days of disciplinary charges after the city discovered that they were working second jobs at another fire department while they were scheduled to work in Cleveland.
Yeah.
And, this has been reported by the news. The Cleveland, and this part shocks me. I'll give all my thoughts in a minute, but the Cleveland Police Department and the city's prosecutors concluded there was no criminal violations. That's part of what I'm going to be confused about in a minute. And then, the 10 firefighters get a couple of days suspensions each. The IFF is challenging the discipline.
Mhm. And I
And
would be too. I would be too.
Oh, good. And I say, oh, good, because I'm going to take the opposite side as you
Yeah.
do.
Good, good. That's good.
So, for example, when in the city of Syracuse, this is a good example, there was a very popular guy who was the PIO for the city of Syracuse fire department. And he, or police department. And he was found to have been working another job while putting in for hours. Now, that's going to be the difference here,
Right.
maybe, but while putting in for hours with another employer, and he was charged with a felony, right? And because that's double booking. Now,
Right.
the question I had here is, did the firefighters receive any compensation when it says they were supposed to be working, meaning they took vacation, they took
Yep.
sick time? I'm assuming not, but if they were supposed to be working, were they still getting paid? And if they were still getting paid, were they double booking for two jobs? That's
Yep.
what's going through my mind. The other thing is, it seems like, well, that's really the question. How are you supposed to be working at one place, yet at the same hour you're working somewhere else? And how is that not either disciplinary or criminal, but at the least disciplinary? And now I turn it
Yeah.
back to you because I'm
So
confused.
I mean, I spent the formative years of my life as a career firefighter in Providence, and I think anyone who's an IAFF firefighter or even or been a career firefighter is going to recognize this immediately as a substitution issue. Firefighters, and that's how I got through law school. Okay. In fact,
Right.
I'm gonna be having we're gonna have a little cookout this afternoon down at the beach with my brother, okay, who was on Providence. He was a couple of years behind me. I still owe him somewhere around 6 months of time for the substituting that he did for me while I was going to law school. Okay,
Okay.
so when you're in a career department, substitutions are like the department sometimes doesn't even want to know they're happening. Just as long as there's a body in the seat that's supposed to be there, that's all that matters. Okay.
Yeah.
So
Yep.
some departments are a little bit stricter than others in terms of documentation. You've got to fill out the right forms and all that. And that has morphed. When I started, it was all pen and paper. It wasn't typed. It was all handwritten on a form. Now it's all computerized in most departments. But bottom line is, substitutions are permitted. In private industry, substitutions are not permitted.
Of course.
The person who's there has to get paid. But in the fire service, through the Fair Labor Standards Act and wage and hour laws at the state level, so substitutions. So what happens, and this is, we're a little bit responsible for our culture allowing this. But many times we don't have strict rules on this because it's a benefit, and it's a big benefit because if you're coaching a little league team or you're a supervisor for the Girl Scouts and you're going on an overnight camping trip, whatever it may be, and you're scheduled to work, it's easy enough. I work for you next Friday night and you work for me Saturday night. It's a swap, it's a substitution, freely allowed. Okay. So what happens over time, and first of all, we don't have very clear rules on what's allowed, what's not. The next thing that happens is somebody maybe, and friends of mine, in fact, the people who built my house who are firefighters, and maybe they're, because of weather, they're behind in a job. So they have someone work for them in the station, and then they engage in their part-time employment. Okay. Now, if you're building a house, you're a carpenter or plumber, there's really very little documentation, especially if you work for yourself, that you were being paid in the fire department and not. But what can happen here, and this is what appears, again, I don't know any of the details behind it, but what it appears is you had career firefighters in Cleveland working legitimately a part-time job, side job for the village of Woodmere. But what was happening, a couple of things it sounds like. One is a substitution for an entire shift where you're scheduled to work in Cleveland, but you actually work in Woodmere, and it looks like you're getting paid twice. That's not necessarily the case. Okay, so that let's kind of put that Exhibit A up there. The other one is where I'm supposed to start at Woodmere at 7 o'clock in the morning, but I'm scheduled to be in Cleveland until 8.
Right. And everybody
So,
accommodates that usually.
well, I'm not sure. It sounds like that's what the department is going after them on. Now, you're not writing on a blank slate here when it comes to Cleveland. Cleveland had one of the biggest substitution scandals in the history of the fire service starting in about 2011. And it was a major scandal. It might have started the way that I was just talking about, but it ended up becoming much bigger than what had happened. So I believe Cleveland, as a result, put some pretty strict rules on substitutions. And so my guess is, and again, I haven't seen a lot in the news. What's been in the news is kind of superficial, but my guess is that they had some fairly strict requirements on substitutions that were violated, and that's what led to the discipline. But on the other hand, you have these firefighters who are working in Woodmere. Well, what about the plumbers, and what about the electricians, and what about the carpenters who are firefighters who are maybe getting away with it? It appears to me that it was because they were working as firefighters or municipal employees for this other village. That's what sort of tied their shoestrings together. It led one of the local TV stations, the I-Team, I guess they didn't have anything better to do, so they went out and started looking at firefighters. But my guess is that there was no fraud here. If there was fraud, if somebody had called in sick in Cleveland and went to work in another community, that's fraud. Right. And you would think that there would be some criminal charges there. So again, if I was representing the local, again, not knowing the rules in Cleveland, I would be grieving it. And it's and here's the problem. Okay, if I have to work Saturday in Woodmere, I'm a Cleveland firefighter. I have to work Saturday in Woodmere, and last Christmas I worked for you, so you owe me the time. And I say, hey, pay me back Saturday.
Yeah.
You owe me the time. What is the big deal? Okay. And why should there be restrictions on you paying me back on that? So I think that there may be, again, I don't know all the ins and outs, but I think for folks who aren't familiar with the way that substitutions work in career departments, this is something that happens on a regular basis. It may not be working in a separate fire department, but working because people owe you time. Now, I think where we kind of go sideways is where people start paying each other to work. And that is something that, in my opinion, it should be prohibited. Substitution should not be an opportunity to either make money or have money being transferred back and forth. So I don't know if that was involved here. That was the root problem in the past in Cleveland. So
and it's interesting. When I was chief for my 4 years, I had the village on one side saying no more substitutions were done because timekeeping is too confusing. And I said, well,
that's unfortunate.
Right. But I responded back, being an advocate for both. I looked at my role as chief as kind of in the middle. right, of the village and the career staff wanted substitution. So ultimately what we came to is substitutions in the same 2-week time period will be allowed, but you have to both give and complete the substitution. It was a middle ground because it allowed timekeeping not to have the issue of somebody owes you.
Because that comes up a lot, and I would encourage fire departments not to put those kind of restrictions in. Okay,
of course.
I'm going to tell one of the things in the FLSA is that the exchange, the substitution has to be voluntary.
Right.
Well, me working for you would be voluntary, but when the fire department says you have to work for me, that's not voluntary.
Yeah,
And
I would argue the whole agreement of I will work for you and you will work for me in the same 2-week period is
Right.
our both voluntary exchange. And if you can't meet that, but I totally get your point. I think the village, in my case, let's not get too far off the stray, but I think the village was concerned incorrectly because of the FLSA about overtime, saying, oh, but if somebody comes in and substitutes and now they're at 55 hours, then we're going to have to pay for that. That was just, in any event, I get it.
That's a mistake. And let's clear that up for the listeners who aren't familiar with the FLSA. Under the FLSA, you ignore the substitution. You don't say, well, Brad worked for Curt, and therefore now Brad's hours go up. No, it's whoever was scheduled. You count the hours of that person who was scheduled, not the person who actually works for purposes of substitutions. So,
and so I explained they're off base, but different issue, different employer. But
I think it's really unfortunate because, the average person works 5 days a week and they work Monday to Friday. We're working Saturdays, we're working holidays. And
we have
the other thing about
on, 2 off,
the other thing
on,
about
24 out, whatever it is.
The other thing about the hour for hour substitution, you work for me Tuesday, I work for you Wednesday. That's fine. Okay. What about Christmas? If you work for me Christmas, maybe working a Tuesday in February is not a fair exchange, and so there should be, let them work it out. If it's somebody's going to substitute on Christmas, maybe it's going to be 2 days in February or whatever the parties decide to work out. But the fire department doesn't need to get involved in that.
Yeah, on the employer side, and we'll kind of end this here. We could do a whole topic on this, right? On the employer side, the employer is saying, wait a minute, if I didn't allow substitution, you would be forced to use your sick leave or medical leave or vacation time.
You're saving money.
And that's what I tried to argue, unless the people get paid, right? Unless the people get paid. But I said, listen, we'd have to pay out hourly in our case for medical leave or vacation leave, but we'd have to bring in time and a half potentially to replace them. I said, it's not even equal. It doesn't matter. Deaf ears, that's the right. But in any event, I agree with you. It's probably not criminal if, and the only reason I think it's probably not criminal is that they determined it wasn't, and they only want a 1 or 5 day suspension. My first thought was, were they putting in sick leave, paid, for, I'm sick, so I can't come in? That would be a different world.
That's a different, and now you're talking criminal. That's fraud.
Right. And we just don't know, but probably not in this case. Okay, let's go to a really great issue. I'm going to sum it up in a very short time, but we can go through it as much as we want. Here, we're in Houston, and an appeals court in Texas has correctly, I'm arm sharing this, I get to do it, correctly determined that an administrator's, not a fire chief's use, right? This is a very important distinction, but an administrator who has true on-duty, off-duty times is not, and this is a fire investigator. I use the term administrator, right?
It's an investigator.
And it's a close call because of the fire investigation. You'll see why in a second. But that because they're defined to be off duty, they had a take-home vehicle. They took it home when their shift ends. And the court determines that when they got into an accident, they had rear-ended somebody. Clearly their fault when you rear-end somebody, usually. And the court determines, look, you weren't on duty. So as the driver of the vehicle, you are not liable. Now, our legal eagles are thinking, wait a minute, who cares? The owner of the vehicle is liable, right? And maybe there's some failure to train, to properly drive. They didn't raise this. And you say correctly in your blog, like, surprisingly, now I don't know if there was a statute of limitations issue or some weird issue why we don't understand, why are you not going after the city on, you own the vehicle, you're liable? Maybe here, maybe in Texas, they don't have that. I don't know. But you and I had the same reaction. You sue the owner of the vehicle and the operator of the vehicle. In any event, we're focusing squarely on one issue, which is great, makes it easy, is the operator of a take-home fire vehicle, when they're off duty, is the operator liable here, or the municipality liable here?
Is the employer liable
Employer.
under what we refer to by the Latin term as respondeat superior?
Right. And the court goes through and says, listen, the state waived immunity for this. They have, they own the vehicle, they waived immunity, but they waived it for certain things, like in the performance of their duties. And the state goes through a whole test, or the court goes through a whole test here, and basically says, you are off duty, you're not performing your duties, so driving off duty, no municipal liability. Okay, but operator liability, why aren't we going after the operator? I have no idea.
And why don't we go after the city as the owner of the vehicle, like you said? But they didn't plead that, apparently.
Right. So now what gets me here is this, and this question I didn't see answered. I scoured for it, but this is a fire investigator, more administrative than operational, but very operational. I assume, I don't know, I'm assuming here when they're off duty, they're off duty. They don't get called out to respond. Not so in my area. Fire investigators are always on duty.
I would think they do. But I think what the court took case law that related to commuting, not about do you get called back, and here's the other one, is the vehicle provided for the benefit of the employee as a perk, or is the vehicle provided as a benefit to the city so that a valuable employee can get back expeditiously?
And I'm assuming the value is to the city, so a fire investigator can go directly to the scene, right? If this was a secretary, a payroll clerk, the HR manager, no issue. Off duty, off duty, that's it.
Yeah.
Right. But the operational task of fire investigation, right? If they are called out, I presume they don't leave, a fire investigator in the station the whole time. So, but if, and maybe this is also the code enforcement officer, I don't know. In any event, if the individual responds from home and is subject to call at any time, the court got it wrong, in my opinion, because they're always on duty. If you're all right. And the reason this is so important is in the volunteer and paid fire chief world, where you're always on duty in case of maybe a third alarm, second alarm, or the volunteer world where the fire chief's always on duty. Yes, they're not on duty at that moment, right? But in most times, it doesn't make a difference whether you're on duty or not on duty, because we're not looking to you for liability under this rule. We're just going after the owner of the vehicle. What does it matter? So this rarely comes up in real life, but I don't want anyone to become too comfortable that if you are on duty and subject to call, you're probably not going to win this way. If you're the secretary, the building clerk, whatever, of course, you get to pay. And there are districts and departments that give take-home cars to some administrators. But
I thought it was an interesting case, but from the lawyer's perspective, the legal eagles out there, you got to watch how you plead the case, and you want to make sure that you go after the owner of the vehicle. In this case, it would have been the city, and you're not liable. You're not alleging liability under respondeat superior. You're alleging responsibility as the owner of the vehicle, and so.
And look, these cases get really interesting. There are cases I read forever ago where they said, I wasn't obligated to respond. I was allowed to respond, right? So a volunteer fire chief, where it comes up a lot, or another fire chief, I'm not obligated to respond off duty, right? But I'm allowed to. It's my decision. And the courts have wrestled with that one. Well, wait a minute. Is that on duty? Is that not on duty? And I think most of the courts, well, I shouldn't say most. Some of the courts have come to what, if you're on duty, you're on duty, you're on duty, you're on duty. And since it's your option to respond, you're making a judgment call. As I recall the court saying, you're making a judgment call in your position of chief that you don't need to go, and you're making that judgment call on duty. So
I
But
think the court looked at cases about commuting, and I
yeah,
don't think that's really the right metaphor here or the right analogy. It needs to be take-home vehicles for police and fire, and if there's any cases on take-home vehicles, police and fire, not commuting,
correct.
but that's how they looked at it, and it is what it is.
So, or did the lawyer screw up? Who knows? These are the times I'd love to hear from one side or the other, like, what
I
was the issue? How did you miss this or not plead that? Or anyway. Um, let's go to Virginia. This one's a pretty universal, but not universal. I'll explain why. We have a higher level court overturned a decision of a municipality to remove the board of directors, president, vice president, secretary, treasurer of a fire company. And in short, the court holds you can't do that, right? You have the power to remove or appoint the fire chief, but that's not the same as the board of directors. And I'm doing bylaws in Virginia for some companies, and it's an interesting it's exactly for me like New York, frankly, where your municipality is in charge of the operational stuff. We can appoint or reject your fire chief, but we can't touch your president, vice president. We can charge you with breach of contract. Anyway, here's what they did. That's what they tried to do. And the court comes back and says, you can't do that. That would be true in a lot of states because the corporate entity is not necessarily the same as the firematic. Where I've seen problems is where and I'll explain what I do. This is important for my volunteer companies out here. But what I try to do is say, the problem is when the fire chief is also the president, which is very common.
Mhm.
And what I try to do when I do bylaws, and you guys should think about this when you do bylaws, and Curt and I at some point soon, we'll schedule a must-have bylaws presentation. But even though the fire chief is president, which in this case, they could have removed him as fire chief and then he would have been gone as president, right, et cetera. And the assistant chiefs, the vice president, all those things.
Well, Brad, let me just stop. I don't
Yeah.
think they could remove him. I think, to me, one of the crux of the Court of Appeals decision
Because it's
was
private corp.
the ability to appoint does not authorize removal. So
Okay.
even though they can appoint the chief, they do not. The court felt like a very strict reading of that. The power to appoint does not authorize the board to remove the fire chief. And then they followed that through for the existing officers. So again, the power to appoint does not imply or infer the ability to remove.
Yeah, and interesting. On that point, there are a ton of cases that go absolutely the opposite way. They say the appoint to remove is inherent in the power to appoint. Here, my caution is, regardless of the outcome, if your president and your chief are wearing the same hat and your municipality can remove, appoint, refuse to approve. Remember, if these are annual appointments, then they can refuse to, now they can remove you by not appointing you again. Maybe you stay in office, maybe you don't. But my suggestion here under bylaws, at least, because this is where this comes from, volunteer company, is even though your president is your chief and down the line, create different positions for president and chief. The same person may fill both positions, but that way, if you are removed, you're removed as chief, but not president. Always. And a lot of my clients, like in Virginia, other places, will say, well, wait a minute. Why do we need two sections? Why do we need an executive officer section, president, vice president, secretary, treasurer? Why do we need an operational section? Why can't it be the same? And this is the exact reason. If you're ever removed, we want to make clear you're not removed from both positions so you can still have a president. I do agree with you. I disagree with the court. Well, I think there are many other courts that would disagree with the court. The line, I could almost quote it, is the power to remove is inherent in the power to reappoint. They're almost the same. I don't know whether I agree. I'm just saying what other courts have said. So, okay, this is a great case. I'm going to give you a background, but we're going to talk about, we're in Arizona and Texas again. We're going to talk more about Texas than Arizona, but you found there were two decisions that basically talk about the anti-gift clause, which I'm going to start with that for everybody. And why, and the question before the courts was whether certain types of time off for union officials to participate in union activities constitutes an unconstitutional gift. Now, let me tell you what an unconstitutional gift is. So I'm going to venture that almost, if not every state constitution, has what's called the anti-gift clause in some form or another. And what that says is a municipality may not make a gift of public monies in pursuit of a private venture. That is basically what it says. And for example, I'll go for a common one. A municipality is not allowed to give an end of the year bonus to an employee for doing a good job. That would be an unconstitutional gift, right? And what you could do is you could have stipends. And what's the difference between a stipend and a gift? A stipend is earned. For example, you're a paramedic, we'll give you another $1,000 because you've maintained or kept your paramedic. The focus, just as it was in Texas and these courts, is whether it is a gift or whether it is exchange for services, a bargained and agreed upon exchange for services. So we're going to give you something and you give us something. What happens here in the court's notes, the Texas court notes, this is a hard case because the parties have asked us only to look at a portion of the contract. And the court notes that you got to look, normally we look at the whole contract because here this may be a real gift if we looked at it on its own to the municipality, and this clause may be a real gift, right, to the union. And the court properly notes, contracts are always this paragraph benefits you, this paragraph benefits us. And if you look at them only individually, one could look like a gift. In any event, what happens here is the court correctly holds that the contractual provisions which allow employees to engage in off-duty union activities and being compensated is, yes, maybe more of a benefit, right, to the union, but it's not a gift, the court holds. It's not a gift because it was bargained for. It also benefits either directly or indirectly. In other words, we gave you this, you got that, right? So the contract as a whole has a bargain for exchange of benefits. And the court says, because of that, it's not a gift. And a lot of things you're doing for union is a benefit to the employer anyway. So I really do like that. What I like is when the court says you cannot should not evaluate a contract on a piecemeal basis, determine what a gift is and is not. They're all exchanges. And the other thing is they say, look, because some of the services benefit the employer, right, it's clearly not just a gift. Bonuses would be a gift. You did nothing except your job and we want to bonus you, that's a gift. If there was no exchange for anything, that's not a gift, right? And again, I don't want people to get confused. Oh my God, you can't give gifts. Well, municipalities can't give gifts. For example, you can give maybe de minimis awards. Here's a plaque, right? But you can't say, here's a gift card for $100, go out and have a meal. And I have clients, unfortunately, doing that all the time. That's why I know this anti-gift clause so well. But
one of the things, Brad, that I took away from this, to me, the seminal issue here was the amount of control that the city retained over the gift. Okay. And in Arizona, where basically the union, 4 full-time union employees were basically given time off. They did not have to report to work. They did not have to document that they were doing things on behalf of the workforce. They could have been doing whatever they felt like. There was not adequate control in Arizona. Whereas the way that the Austin firefighters collective bargaining agreement was worded, it gave the city the ability to approve or not approve of each time off that was going to be granted.
But through the fire chief.
Yeah, absolutely. Yeah. Yep. So I think that, to me, that was one of the big takeaways here.
Yeah, that's a big factor.
I thought with Arizona, their interpretation of their gift clause, you're working as an attorney, you're working in one specific fact pattern here about municipal employees, unions, and yada, yada, yada. And you may not even be thinking about how this could impact something like a new football stadium or a new baseball stadium. And if the community is going to be building the stadium with the idea that we're going to get more tax revenue, we're going to get other things like that, there's language in here that would suggest that that is a gift, that if we're going to build the Arizona Diamondbacks a new baseball stadium, okay, or the Cardinals, a new football stadium.
In Buffalo, where they're actually using New York tax funds to build the new Buffalo Bills stadium.
That you can take some of the language in that Arizona case and you apply that and you say you can't be using taxpayer funds for that.
Right. Except the quid pro quo is we're going to get sales tax, employment, right? There is a
But they
quid
were
pro
saying
quo.
you can't have a quid pro quo.
Right.
That's what I mean. Some of the language, and that's why judges are
Concerning.
going to be very careful when they're working in one specific fact pattern involving a labor union and a contract and the gift clause, and they may not realize, holy cow, let's apply that in a different scenario. And now we just created a problem. And
Yeah.
now we got to put the backup alarm on and back out of this somehow.
And you got to find the public benefit, right? There has to be a public benefit to not be a private gift at a minimum.
Mhm.
Texas is one of those cases, and anybody who's ever interested in the anti-gift clause, that they should read it because they did a really good analysis. They really scrutinized the whole relationship, right? Not just made general statements. They really scrutinized the relationship and looked for what is the quid pro quo, what is the public benefit, and
Mhm.
is it merely a gift? And again, they said, they were very clear. You have to look at the whole contract, even though they weren't allowed to. They felt you really need to look at the whole situation, not just piecemeal. So it was a great decision. I like when you read decisions, you're like, yep, that's the right one.
Okay.
Okay. So lastly, let's go to Hackensack, where Hackensack, New Jersey, right? Bless you. They sought the firefighters are seeking overtime for off-shift inspection work. I'm going to jump right to you and like, what are
Yeah.
your thoughts here?
Well, this is a tough one without knowing all of the facts, but here's the bottom line. You can pay somebody $30 an hour for one job and $25 an hour for a different job. And we do it all the time, okay?
Right.
And we tend to think of firefighters, lieutenants, captains, battalion chiefs. The FLSA and wage and hour law doesn't look at that.
Which they didn't proceed under the FLSA here,
Right.
interestingly.
So basically, you can pay someone $25 an hour to do a certain job. You can pay them $30 an hour to do a different job. So do inspections, you can get $25 an hour. Do assign to an engine company, you get $30 an hour. Work on
But,
an EMS unit as a paramedic, you get $40, whatever it may
but
be. Okay. So
combine the hours.
there's nothing inherently wrong with that. But now what happens is when it becomes overtime, the hours that you work at $25 an hour has to be added in and factored in with the hours that you worked at the other. You can't just say, no, that's a $25 an hour job.
Right.
Now, for every general rule, that's the general rule. For every general rule, there are exceptions. Okay. One of the exceptions that often comes up are paid details. So in Providence, we have the Providence Civic Center. We've got different, venues all around the city where we have to have firefighters on duty. Paid detail hours don't count toward your hours worked.
Under the FLSA.
Under the FLSA.
Not under the normal wage and hour laws, I'm guessing. I don't know New Jersey's wage and hour laws, but
they often are identical, but it's possible. And again, I'm not sure of what the specifics are under New Jersey law. I am a little bit shocked that firefighters make $72 an hour in New Jersey and $108 an hour for overtime. I think that's California wages. So,
yeah.
but
Yeah.
at any rate, the issue here, I think, is really about whether or not those hours need to be included in their hourly calculations for each work period. And the firefighters may, if indeed they are making $72 an hour, there's nothing wrong with them making $72 an hour for working on a fire truck and $25 an hour while on inspections. But there's a counterintuitive thing that they might not have been thinking about, is that you've got to average the hours. We call it the blended rate. And that will actually bring their hourly wage down for overtime purposes. So there's a potential downside to this in terms of.
Let's just expand that so people understand, right? So the most common place, I think, where departments screw up. So for example, my overtime rate or my regular rate's $40, right? But I also get an hour. But I also get, let's say, a $2,000 guaranteed end of the year bonus, right? So my overtime rate is not just time and a half of 40, it's time and a half of the 40 plus the 2,000 divided by 365, right?
Yeah.
That gets me that hourly rate. That's the normal screw up I normally see. Here, I agree with you. It doesn't look like they're seeking it properly. They should get the average rate of both jobs combined, plus any stipends, et cetera.
Right.
That's
It's going to
their
be
average
pro
hourly
rata. It's
rate.
going to be pro rata. So if they work 40 hours at $72 an hour
Right.
and they work 10 hours at $25 an hour, it's going to be pro rata, but it actually reduces their overtime rate. So yeah, I don't know. There's a counterintuitive part to this that I'm not sure they fully comprehend. Maybe they did, and maybe they said, you know what, it still is. We're still going to
Still
come out
more.
on top.
Right.
Okay. Or they may say you should have paid us 72 hours for all those hours that we worked.
Right. And I'm curious how we're getting to a suit. Normally there's, a complaint, a negotiation, a grievance, right? And then we get to the suit. I'm curious how we're getting to the suit that the employer's not saying, okay, we owe you something. We
Right.
owe you something. And they start paying at least something. I'm shocked. They're going to say we owe you nothing.
Yeah.
Or much less, or I don't know.
It's really weird. And I would have thought also that if they're going to go under state law, you probably would have filed a grievance. And I'm not sure why they wouldn't have grieved it. But at any rate, they're going on. Maybe they have in the past and they lost the grievance. So they're going to go this route. I'm not sure.
Not sure. Well, that is it for a very interesting, diverse week. We didn't have any of our normal harassment, retaliation. I want to give a quick shout out to the departments I met with who were great down near Fort Myers, Florida last week. I had a great 3.5-hour lecture on must-have policies, which, as everyone knows, just scrapes the surface of what Curt and I can offer. But it was a great department, really interesting. I love seeing other departments and how they, are the same or different. Great group of people. They didn't get any calls out despite they run 12,000 calls a year. That was impressive. But neat area. And I was down in Florida for the hurricane. So some of them had been deployed up where I was in Sarasota. And wow, a lot of rain, no hurricane, but a lot of rain, record downpours. In any event, shout out to them. And, it's to all our other viewers. I realize, we are coming up on 2 years, are we not?
Yeah. Oh yeah. Yeah.
And, when it's one thing saying over 2 years, but when you think how many episodes we do, 50 episodes a year, you're talking a lot of episodes here.
Oh,
so
absolutely.
I'm wondering where 100th comes.
We might actually be coming up on 3 years.
Is it really?
Yeah,
wow. In that case, time really flies.
It's 2.5. I think it's 2.5 years.
Wow.
But
Okay.
But I want to give a shout out to the folks I'm going to be seeing next week up in Foxborough. This is a great time of year to be up in Foxborough. The football players are up there, the families are there. There's a lot of energy up in the Foxborough area. So I'm excited to be up there for my advanced discipline class. And we're cranking out those policies for those of you who are, have subscribed, man. We're cranking them out. So
every 2 weeks, people are getting policies.
Yeah, we don't want to overwhelm you. So, but we're, they're coming out, couple every week or so. So,
Yep.
All right.
Very good.
Well, that's going to do it for another edition of Fire Law Roundup. We'll see you all next week.
See ya.
Take care, Brad.